Hello and welcome for joining me. My name is Gail Lee and I'm a solicitor at McHugh Lawyers in Chatswood, Sydney. My main areas of work include family law, civil litigation and wills and estates, and I have created this 5-part series on the basics of family law in the hope that it's going to be able to provide at least some guidance, a little bit of assistance to people out there who are having to go down this pathway for the very first time. So part 1, which is what you are viewing now, begins by looking at the bigger picture. So what legislation applies and other rules and regulations, where to find it, what options are available to you, and a little bit about the court themselves. So let's begin. Okay. Actually, before we go any further, what I'll do is I'll just quickly go over each of the parts of the series, beginning obviously part 1, legal regulation of families and the court structure, which is what we'll be doing now. Part 2, separation and divorce. Part 3 concerns children's issues, such as the best approach method that is adopted, parenting rights and the law, parenting agreements, because there are actually a few different types of agreements that you can enter into, the court's approach when dealing with matters relating to children, child support as well. Part 4 concerns property settlement and essentially how the court deals with property settlement. And Part 5 concerns other issues which you see commonly occurring in family law proceedings, such as family violence, the issue of relocation, non-compliance with court orders, spousal maintenance and costs. Right, moving forward. Alright, so when it comes to the legislation in Australia concerning family law, the main piece of legislation which you will come to know is called the Family Law Act 1975. Now this is a Commonwealth Act, so it applies to all states and territories except Western Australia up to a degree. So in Western Australia they have their another piece of legislation called the Family Court Act 1977. Now the Family Court Act applies to parenting and property cases relating to de facto couples. So if you are listening to this and you're in Western Australia and you are a married couple or formerly married couple, then the Family Law Act Commonwealth will apply to you. But if you are part of a de facto relationship, then it's the Family Court Act that will apply to you. You also have court rules and procedures and regulations. Now, it depends on which court you are in. So if you are in the family court, then the family law rules and the family law regulations will apply to you. If you're in the Federal Circuit Court, then the Federal Circuit Court rules and the Federal Circuit Court regulations will apply to you. Now, this is where you go when you're trying to ascertain things like how long your affidavit is permitted to be in interim proceedings, what type of form you're meant to file, whether or not you're allowed to issue a subpoena without leave of the court, how many subpoenas you're allowed to issue. These are all matters that become relevant once you are engaged in family law proceedings. Okay, so other legislation that plays a part includes child support legislation and legislation about family violence. Now, the two main pieces of legislation concerning child support is the Child Support Assessment Act 1989 and the Child Support Registration and Collection Act 1988. The Child Support Assessment Act, it sets out the law about eligibility to receive and the liability to pay child support. It also establishes how child support is calculated and the authority of the child support agency itself. The Child Support Registration and Collection Act, however, it sets out the law about the registration requirements for paying maintenance and the means by which the child support agency can enforce payments. Although the Family Law Act recognises family violence as a relevant factor in family law proceedings and offers certain protections, the actual illegality of family violence and other specific forms of protection against it, for example, the issuing of an apprehended domestic violence orders, these are issues which are primarily dealt with under the specific state and territory legislation. So where do you actually find all of this legislation? Look, the most easiest way to find it is at a website called Ostly, and you can see the website address down there. It is free and you will be able to access full text of all family law legislation and even some case law. You can also find the relevant legislation by doing a Google search. It will come up with different ways that you can source it. Also, the actual court websites themselves, the Federal Circuit Court and the Family Court, that will be able to provide you access with to the actual rules and regulations and practice notes. Alright, so in Australia we have two main courts that deal with family law proceedings. The first of these is the Family Court of Australia. The other is the Federal Circuit Court of Australia. Now, the Family Court of Australia is what we refer to as the Superior Court of Record. Judges there have the same status as a federal or Supreme Court judge. One judge will hear the proceedings at first instance. However, if your hearing was then subject to an appeal, your matter would be listed before 3 judges of the Family Court. It deals with more complex cases. As a general rule of thumb, if your matter requires a final hearing that would require more than 3 or 4 days, then your matter would be filed in the Family Court of Australia. The other court, the Federal Circuit Court of Australia, it tends to deal with less complicated disputes. It's intended to provide a faster and cost-effective option for litigants and to try and ease the workload of the Family Court. Look, the reality is that both courts are overburdened and under-resourced. Do not expect your matter to be handled expeditiously, and that's not through any fault of those who work in the system and try to do their best to have matters listed and heard as quickly as possible and dealt with as quickly as possible. The reality is that there are limited resources, and also there are urgent applications that come along the way which bump things further down the list. But if you are of the view that your matter would be not complicated, would maybe require only 2 or 3 days of hearing time, if it was to proceed that far, then you would file in the Federal Circuit Court. So you're probably wondering, oh my gosh, so which court am I meant to use? How on earth am I meant to know how many hearing days I will require if it went to final hearing? In most cases, the vast majority of cases are filed in the Federal Circuit Court of Australia, unless you are aware right from the beginning that your matter is going to be concerning issues of family violence or child sexual abuse. Perhaps there might be questions concerning the jurisdictional right of a party to be heard in Australia, and therefore there's issues of law to be dealt with first, or it's concerning matters to do with international relocation or child abduction. Then your matter in those instances would be listed in the Family Court of Australia. Otherwise, file your matter in the Federal Circuit Court of Australia, but don't worry. Look, at the end of the day, if it becomes obvious that the matter needn't be dealt with in that particular court, it will just be sent to the other court to be dealt with. Something you should be aware of, though, is that in May 2018, the government announced its intention to merge the two courts. This was really to try and streamline the process and avoid the scenario where matters were having to be transferred from one court to another and you're having different rules and regulations of applying to different matters. However, although it was meant to become operational on 1st of January 2019, this has not occurred because there have been a number of concerns raised with respect to merging the courts. At the time of preparing this slide, I have no knowledge as to whether or not or when those courts will be merged, although my understanding is that there is still an intention to do so. Okay, so the next question we're going to be looking at here is, do you have to go to court? Look, the short answer to that is no. Okay, in an ideal world, no one would have to go to court. And in fact, the vast majority of separating couples actually do manage to resolve their property and parenting arrangements in private without the need for court intervention. So just because you have separated does not mean that you are obligated to go to court to have your property and your parenting arrangements formally recognised. You can actually do this on an informal basis without the need for court stamped approval. We will discuss that a little bit later on as well. The other thing too is that you need to be aware that there are avenues open to you other than court. You have counselling, there's family dispute resolution, there's mediation, arbitration, conciliation and collaboration, to name just a few. Now, without going into any specific details, I will just touch on a few points briefly. So with counselling, look, don't underestimate the value of counselling. You're not unique if you are experiencing extreme feelings of anger, hurt, frustration, sadness, separation. It is difficult. It is, in many instances, it's like grieving for something that you were hoping was going to happen, but, it didn't eventuate. So counselling can be a very useful resource available to you, and it needn't be expensive. There are actually free counselling services out there that can help you work through the emotional side of things in the hope that it can avoid exacerbating the conflict that often comes up involving separation. There's also family dispute resolution. Now, FDR is a type of mediation which is adapted specifically to the family law system. So FDR, it's carried out by an independent family dispute resolution practitioner. It's not by a lawyer, and it aims to help parties to try and resolve disputes without the need to go to court. Now, I'll come back a little later to FDR because when it comes to family law litigation, there are compulsory preliminary steps that must be followed before you can file and initiate an application in court, and family dispute resolution is part of that. You also have mediation. Now, this could be a private mediator. It's really not that hard to find a mediator that is able to offer services, and the fees can also vary widely. What may seem very expensive to begin with may end up saving you tens of thousands, if not hundreds of thousands of dollars later on. Arbitration is another avenue. Now, arbitration is not something that you would go to right from the beginning. Okay, you would probably have engaged other services first, such as mediation or counselling. You may have already also engaged a solicitor. You've pretty much got everything, all your ducks lined up in a row. You just haven't filed anything in court. And it's like a mini court process. So you'll have an arbitrator who will essentially make orders, which have to be followed by the parties after listening to each side's position. So it's a quicker way of trying to resolve a conflict. There's also conciliation. This is where you have a form of mediation. This is where you have a conciliator who will liaise between each party to try and resolve the issues that are in dispute and come to a negotiated agreement. Another service which is probably not as well known, but one that I do actually prefer where possible, is a process called collaboration. Now, it is one that I would certainly recommend. I'm not a qualified practitioner for collaboration, but I would refer my clients on to somebody who is. Now, collaboration is a form of alternative dispute resolution, which is suitable for parties who have it within them the capacity and sincerity to act in good faith, to be open and honest. They both have a mutual understanding and wish to not go to court and be able to work in a way that comes up with creative solutions to the issues which they are having difficulty working through. Now, the thing about collaboration is that the solicitors who help them are actually disqualified from acting for their client should the collaboration fail. So this is a very motivating factor. The idea of having to start again and brief somebody else, that's a big stick in order to try and resolve the situations amicably. Now, which of these ADR pathways are the most appropriate will depend on your particular circumstances. Issues such as cost, the time, whether or not there's issues of family violence, the party's ability and or willingness to participate, these are all factors that will influence what form of ADR practice suits you best, if at all. As you can see, however, the services available are many and varied, and for further information you can do simple Google search, you can contact the Law Society, or you can go to the Family Relationships online or call the Family Relationships Advice Line, and they be able to provide you with information relevant most often to either counselling or family dispute resolution. Advantages of early private settlement. Now, it seems like a bit of a no-brainer, but let's go through these anyway. Cost. Look, it's not just the legal fees, and they can become quite exorbitant, but also lost income earning productivity. If you are having to take days off from work to go to attend court, to brief counsel, to see your solicitor, even to do things like answering emails, providing documents that you require as part of your obligations, this is all going to affect your productivity in the long run. The benefits to the kids, look, the earliest return to a low conflict cooperative parenting arrangement, the better. Research has shown that. Let's just move on. Getting your own solution is going to be far better than one that is imposed on you by the court. So an agreement you make is more likely to be satisfactory and appropriate for your specific circumstances over time than one that's imposed on you by the court. But not only that, you need to appreciate that if you have kids involved, your ex is someone who is going to be in your life for some years to come, like it or not. So it would be far better, if possible, to be able to be on terms which are amicable and cooperative. Going to court, it is a gamble. The court's primary focus is on the best interests of the children and finalising property arrangements. It's not what you want or what you think is important that matters if at the end of the day the court feels it doesn't meet the court's objective. It's going to be much, much quicker coming to your own negotiated settlement than if you were to start filing proceedings in court. Now, I appreciate that in some cases you have no choice, the other party is belligerent or they're non-communicative, and the only way you can really get things moving is to file proceedings in court. But I would implore that that is not the first option, to try your best to engage those other services that we spoke about briefly before. It also has a lower emotional toll. Again, if you are caught up in proceedings for the next 3 years, which is the average time at the present to come to a final hearing, that's 3 years that your life is on hold before you can make any firm decisions. So it's a bit of, again, sake of repeating myself, it's a lower emotional, it's far better if you're able to come to an agreement yourself. Now, something I will just touch on now as well is the issue of confidentiality. So when you are engaging in forms of mediation, generally speaking, all communications are confidential. This is because you wish to encourage participants to be open and honest in their dealing with each other as much as possible, and this won't happen if there is concern that what someone says or provides during the mediation may be used against them in court later on. There are exceptions to this rule, particularly where there is a risk of abuse to a child or family violence. In some instances, the parties may consent to the use of the information, so that would also be an exception. The main objective, however, is that it is in the public interest that documents and information provided during the parties' engagement engagement in something such as counselling, family dispute resolution, or mediation, or collaboration, or conciliation cannot be used other than for the purpose of negotiating a settlement. Now, remember, though, that what we're talking about here are what options are available to you instead of court. If you have already engaged in proceedings and you are subject to a court order for, let's say, family dispute resolution for the purposes of the court to obtain a family law report, then this report will not be confidential. Pre-action procedures. Now, I touched on this very briefly earlier on, so we'll expand on it now. The Family Law Act requires all parties who have disputes in relation to their children to engage in alternative dispute resolution processes. So whether you like it or not, you are going to have to do something to show the court that you have made a genuine effort to resolve the dispute before starting a case. There are exceptions to this in limited circumstances, which are set out in the Act. Specifically, Section 60I of the Act provides that the object of the section is to ensure that all parties who have a dispute about children make a genuine effort to resolve that dispute, as I just said. The exception to this requirement is where orders are sought on an urgent basis or if there is family violence. Now, be careful here, because what you may consider to be urgent, the court may not agree. It is therefore advisable that you seek legal advice in relation to your application so that a proper assessment can be made as to the degree of urgency. But more importantly, if it is urgent, your solicitor will be able to assist you with your affidavit, which you must file in support of your application, because your affidavit must properly detail why it is urgent and what steps you have taken to try and resolve the situation before coming to court. If you fail to do that, your application will be rejected and you have just wasted a lot of time, money and energy, and you will have to start again after first going and applying for your 60I certificate. Now, a tip is that although the pre-action procedures are generally only mandated for in proceedings in the family court, not the Federal Circuit Court, as I said, the Family Law Act still requires all parties who have a dispute involving children to participate in the alternative dispute resolution processes prior to filing and initiating application. So on that basis, when you go and engage a professional for counselling or mediation, make sure that they can issue you from the outset a Section 60I certificate, because it's killing two birds with one stone there if need be. If you engage the services of a family dispute resolution practitioner, they can issue you with a 60I certificate. Now, if you're also trying to find where the pre-action procedures are, they're set out in Schedule 1 of the Family Law Rules. Okay, so that brings us to the end of Family Law Introduction to the Basics Part 1, Legislation and the Courts. I hope you did get something of value from that. Please feel free to contact me if you have any questions. I wish you luck. Thank you.